Welcome to the Bible Forum. I'm Warren Sprouse. I want to talk to you about churches versus movie theaters. Unraveling the Supreme Court's recent decision against churches. In a tie vote, Chief Justice Roberts broke the tie, allowing California to place tight restrictions on churches. If you read the dissent by Justice Kavanaugh, you will be glad you supported his nomination, if you did. Apparently, the tie-breaking no vote was motivated by what we see in movie theaters and shopping malls. The question is, why are we making comparisons with movie theaters and shopping malls? Well, starting in the 1920s, in a case called Meyer versus Nebraska, the High Court started requiring states to obey the federal Constitution with regard to substantive rights that heretofore had been controlled by state constitutions and state bills of rights. That doctrine became distilled in a categorization of our rights into two groups: the fundamental rights and the non-fundamental rights. Higher protections went to fundamental rights. In a fundamental rights case, the government must prove that its actions are justified by a very high standard, something called compelling government interest, and it must be implemented in the least restrictive means possible. This standard is deliberately designed to make it hard for the government to win when it tries to override a fundamental right. In non-fundamental rights cases, it's a lot easier for the government to win. The difference between the Roberts opinion and the Kavanaugh opinion is that it boiled down to whether they thought churches were treated equally or not. If they are treated equally, then the law is general and neutral. If treated unequally, then the stricter legal standard is invoked. Why the difference? Both justices approached the subject on the basis that the key fact is whether churches were being treated equally with equivalent secular businesses. But again, why? I thought religious freedom was special. Well, it seems this all stems from a decision written by Justice Scalia in 1990. Scalia, ever the conservative, wrote the majority opinion in the case called Employment Division versus Smith. That case involved Native Americans who were fired from their jobs as drug counselors for taking the drug peyote in a religious ceremony. Now, even though the case could have easily been resolved in the government's favor without destroying religious freedom, Justice Scalia led the majority into a troubling opinion, writing that religious people and institutions cannot get a religious exemption from a neutral law of general applicability, and that there are few exceptions to this concept. For example, if a law requires all doctors to perform abortions, then this case, this law, would not help. The argument would be that the law is neutral and general. This is not to say that there aren't other kinds of defenses that may also be available. The rule is contrary, however, to parallel rules with other First Amendment rights. For a very long time, it was illegal for corporations to spend money to endorse or oppose political candidates. But the corporations that own newspapers were exempt. Why? Because it is unconstitutional to apply a neutral and general law in a way that restricts a First Amendment freedom. Before the Smith decision, the church/COVID case would have turned out differently because it would have been decided on this rule. Even a neutral and general law cannot override a fundamental right, absent proof of a compelling interest advanced in the least restrictive manner. But because of Smith, many of the protections of religious freedom were diminished, and the battle is all about comparisons. Are churches more like movie theaters or shopping malls? Well, in the end, they're neither. However, the law is blind, apparently, to that. This is what you get into when you start looking at the law. Have you ever spent time with the law? The law is very, very complicated, and when you start reading about these things, as I just read them to you, it's hard to follow. But the lawyers know it, and apparently they know what they're doing. If it wasn't for that one case, this one guy smoking this drug in a religious ceremony, or these guys, plural, this whole thing would have been handled differently. And a conservative justice is the one who wrote the case. It's amazing, isn't it?